Evergreen Investments, a Montana company, was negotiating for 2 years to buy FCL Graphics, a commercial printing firm located in Illinois. The parties signed a letter of intent that included a purchase price of $53 million, payment terms, and the precise assets involved. The letter also stated that binding terms and conditions for a potential transaction will depend on a number of factors, including but not limited to the satisfactory completion of legal, business, and financial due diligence investigations and negotiation and execution of definitive legal documentation. Any proposed transaction will be subject to Evergreen's ability to arrange financing on terms satisfactory to Evergreen, sufficient to consummate the acquisition and provide adequate working capital to meet the company's ongoing liquidity requirements and other obligations. Consummation of the sale was also contingent on Evergreen obtaining satisfactory financing, the receipt of certain approvals, and Evergreen's completion of due diligence. 1 month after signing the LOI, FCL terminated negotiations. Evergreen sued for breach of contract. The trial court granted summary judgment for FCL, ruling that the letter of intent was not a binding agreement. Evergreen appealed. Do you think that the letter of intent is a binding agreement? In the courts, the judgment for FCL affirmed. Excerpts from the court's opinion are as follows. Whether such a letter reflects a binding agreement between the parties turns not on what the parties subjectively believed, but on what they expressly manifested in their writing. If no ambiguity exists in the writing, the parties' intent must be derived by the court, as a matter of law, solely from the writing itself. The clear language of the letter demonstrates that the parties did not intend the letter to constitute a binding agreement for the purchase and sale of FCL. The remainder of the letter clarifies that this was a proposed acquisition and a potential transaction that depended on and was subject to several factors and conditions, including but not limited to the satisfactory completion of legal, business, and financial due diligence investigations and negotiation and execution of definitive legal documentation, including non-competition agreements with all existing owners, as well as certain legal, regulatory, and other necessary third-party approvals. The court noted that the letter of intent contemplated preparation by counsel of a formal agreement and stated the parties would act in good faith to attempt to reach agreement on terms substantially similar to those in the letter of intent. The parties negotiated for 2 years and agreed to a letter of intent with the purchase price, payment terms, and assets to be sold. Why wasn't that enough to create a binding agreement? Well, the letter of intent left out many outstanding issues. For instance, Evergreen required additional time for satisfactory completion of legal, business, and financial due diligence. What does that mean? Due diligence is the process of investigating all the facts and circumstances surrounding a transaction and deciding whether to proceed. In an asset purchase such as this, the buyer would inspect the physical condition of all tangible assets, the title history of any real property, the presence of oil or hazardous materials in the ground, whether buildings had received all necessary zoning and regulatory approvals required for construction, 3 or more years of financial statements for any going business, and anything else that could affect the value of the assets being purchased and the risk of owning them. But why is this significant that Evergreen still needed to complete its due diligence? Because the letter of intent states that agreeing on binding terms and conditions for the sale depend on Evergreen's satisfactory completion of its due diligence. Does satisfactory completion mean that Evergreen could decide not to go forward if it wasn't satisfied with the results of the due diligence? Yes. Then why did they go to the trouble of writing and signing a letter of intent if it had no legal effect? Why bother? The letter of intent captured the state of their negotiations, showing where the parties agreed and where they did not. In complex negotiations like this one, which went on for 2 years, it's critical to the business people to keep track of the terms of the proposed deal. That's a major reason for creating the letter of intent. If the letter of intent is often important for business people, why do lawyers like to use them as well? Well, lawyers use them for the same reasons, to narrow down the field of open issues and keep track of all the deal points. In a complex deal such as this letter of intent, it can be quite lengthy. While lawyers recognize their value, they are also wary of creating a letter of intent that the other party can construe as a binding agreement. An offer is an act or statement that proposes definite terms and permits the other party to create a contract by accepting those terms. But sometimes we forget that by making a valid offer, we give that power to the other person. Sometimes corporate offers forget the point as well. Nationwide Mutual Insurance Company wanted to energize a regional meeting, so it announced a contest for the best company slogan to be used at the convention. They said, here's what you could win, his and her Mercedes, or an all-expense-paid trip around the world, additional prizes to be announced, and all prizes are subject to availability. David Mears and 184 other employees entered. Mears' slogan, at the top and still climbing, was the winner. One company officer told Mears that he had won the 2 cars, but another said that the cars were just a joke. Ultimately, Nationwide informed Mears that the prizes were never meant seriously. The company did, however, use his slogan for the convention. The banners, booklets, and balloons all echoed with his phrase. Mears failed to see the joke and filed suit in federal court. The jury didn't laugh either. They awarded Mears $60,000, the value of 2 of the least expensive Mercedes. The trial judge gave a judgment, NOV, for Nationwide, ruling that the terms of the agreement were too vague to enforce. On appeal, however, the 8th Circuit Court of Appeals agreed with the jury and reinstated the $60,000 damage award. The contract was unilateral. One knows this because Mears accepted the offer by tendering performance, not by making a promise in response to Nationwide's offer. Nationwide did not intend their offer to be taken seriously. They apparently wanted employees to suggest slogans, but considered the prizes to be a joke. If Nationwide didn't intend to be taken seriously, then why did the jury find that Mears accepted it and created a contract? Well, there's a difference between subjective intent and objective intent. Subjective intent is what people believe or feel in themselves. Objective intent is what a reasonable, neutral third party believes to be a person's intent based on their words and conduct when making the offer. The terms of the offer was fairly vague, and the trial court thought so, so it entered a judgment of NOV, non obstante verdicto, after the jury decided in favor of Mears. A judgment NOV is a procedure that allows a judge to overrule a jury's verdict if the judge does not believe the evidence supports it. When the case was appealed, the court reversed the judgment NOV and reinstated the jury's verdict, awarding $60,000 to Mears. So, what lessons should we draw from this example? Be careful proposing anything that a court might construe as an offer. Vagueness or ambiguity in an offer or acceptance guarantees problems and may lead to litigation. The executive or consumer who articulates to herself precisely what she wants and then bargains clearly for it is likely to spend more time doing business and less time in court. Congratulations, you made it through Chapter 11 on agreement.